Hi there, my name is Muhammad Ghazali, and today I'll be talking about Probate and Administration Act 1959 and the point of view of Dworkin right thesis. Okay, we start with the man who created this theory. The person who we're talking about is Ronald Miles Dworkin. He was born on 11 December 1931 and died on 14 February 2013. Ronald Dworkin was American philosopher, jurist, and also scholar of United States constitutional law. Okay, we move on to background of Probate and Administration Act 1959. This act was known as Probate and Administration Act 1959 or Act 97. This act was relating to probate and letter of administration. It was first enacted on 1959 and during that time was known as Ordinance number 35 of 1959. Then it was revised on 1st November 1972. This act was came into force on 1st February 1960 for Peninsular Malaysia and on 23rd of June 1972 for Sabah and Sarawak respectively. All amendment in this act has been incorporated up to 1st October 2009. Okay, now we move on to the development of Probate and Administration Act 1959 in three stages of interpretation by Dworkin. Okay, we start with the pre-interpretive stage. This act was introduced as to govern the estate of the deceased, as for previously many individuals does not have the knowledge on how to administer and to get the right of the deceased. As provided under Probate and Administration Act 1959, administration means authorizing the person therein named to administer the deceased person estate in accordance with law by issuing letter of administration by the court. Why? Probate means a grant under the seal of the court authorizing the executor therein named to administer the testated estate. Okay, now we move on to the interpretive stage by Dworkin. Okay, as we know, the purpose of probate is to establish a clear title or ownership to deceased asset after their death. Then the administration will be executed based on the right that has been acquired from the court. Thus, the rationale behind the existence of this law was to help the deceased executor or administrator to obtain the power to deal with the deceased estate, as well as to lay out the procedure in accordance with law for the estate administrator after the death of a person. Thus, by using this law, the executor can use a grant of probate as stipulated in the Act if there is a valid will to administer the deceased estate. Why? Letter of administration will be used in the situation if there is no valid will to administer the deceased properties. Thus, the benefit of having this law was because it is an important legal instrument which authorizes and triggers the process of estate administration. Also, it is help in determining the right and legal transfer of ownership of all possession and assets upon the occasion of an individual death. As for the post-interpretive stage, as what Dworkin theory stated, we need to evaluate whether this law was good and bring benefit or not. As what I already stated, and in my humble opinion, this law should be maintained to be used in the following years. The reason why is because this act has all the necessary things to explain to others in how to administrate one deceased person estate as accordance with law, as well as the necessary steps to be followed with. Basically, using this law, we can know the right way for estate administration, as it is really important in a way to ensure that the property were distributed accordingly with the intention of the deceased to the correct friends and members of family whom will receive the asset of ownership for the property. Hello there. Okay, after I have explained about the Probate and Administration Act 1959 from the perspective of Dworkin right thesis, so I will give my reflection as to the significance of those three stages of interpretation in understanding Probate and Administration Act 1959. Okay, as we know, by using Dworkin right thesis, we can manage to find our right as the executor for the administrator deceased properties, and for the beneficiaries as to know their right to the deceased property. So during the pre-interpretive stage, I found some common principle and rule or section regarding for the right to administer deceased property. So also we know the right procedure as what need to do when there is situation when somebody pass away. And then during the interpretive stage, I extensively investigate the act and found few of rules and principles identified in order to identify the primary ties between the rule and the right for others. As in the rule, we can see the meaning of probate and administration, which give us the clearer view on what the right and the correct rule to be used in situation where the deceased died leaving a will or not, by using grant of probate instead of letter of administration. That is for the example. So meaning that the people, others will know their right to use this rule. And then for the post-interpretive stage, it offers some scope for critical reflection on how does a rule really have to be interpreted, and is it better to serve the justification which give a valid right to the user. As I mentioned previously, by using this law, we can know the right way or the correct way to administer the estate of a deceased, as it is really important in way to ensure that the deceased property were correctly or justifiably distributed accordingly with the intention from the deceased himself. Thank you.